As Mike said, the topic of my talk today is conceptualizing trust in the modern welfare state. And before getting into what exactly that means and what are the specifics of that topic, I'd like to give you a bit of background as to where this comes from and what I'm doing in terms of my doctoral research, so where it all fits in. And in doing so, hopefully I can give you a bit of perspective in terms of the applied value of this conceptualization, because as you'll see shortly, it'll be quite theoretical and quite conceptual. But I hopefully can give you a bit of that practical element so that you can take something away from it. So broadly speaking, what I try to do in my research is I'm exploring the role of trust as a political, philosophical, and sociological concept in what I refer to as the administration of social welfare entitlements or social rights. And so when I talk about social welfare entitlements or social rights, what I'm talking about is rights or entitlements to things like healthcare, education, food, water, housing. And the reason I put administration in air quotes is because I'm not talking about just the state's delivery or provision of these services, but I'm thinking of it in a bit broader of a context. And I'm thinking about it in what I consider to be kind of four sub-processes. So one would be the drafting and promulgation of framework legislation by the legislature. Two, the implementation of social program or social rights by way of social programs by the executive branch, including the relevant administrative and regulatory agencies. Three, we have the lawyers, so talking about judicial review of legislation and administrative action by courts where such judicial review is available. And then fourth, the implementation of those courts' rulings by state actors who are subject to those rulings. And so essentially what I try to do in my research is use the concept of trust as what I consider a perspective from which to look at social rights administration. So a new way, a new kind of outlook or framework in which we can examine this process. And in particular, what I do is I use that concept of trust to achieve what I consider to be two principal objectives. So one, I use trust in order to reconceptualize the field in terms of trust and what I call trust relationships. And I'll get into a bit more detail what I mean by trust relationship. But what I try to do by using trust and by reconceptualizing in this way is I'm trying to, first of all, kind of get us out of our comfort zone. So stop talking about social rights, healthcare, in the ways that we're used to in the discourses that we're accustomed to, but to talk about it in a new way, and hopefully trust does that to a certain extent. Also, by reconceptualizing in terms of trust and these trust relationships, I also think that we open ourselves up to what I consider to be a wealth of social science research on trust. And when I talk about a wealth of social science research, I mean there's a lot out there that's been written on trust. And it's not limited to sociology and philosophy, but we have psychology and management and organizational behavior, and the list can go on and on. And there's a lot of really valuable ideas that are being thrown out, but that just haven't been, at least in my view, successfully incorporated into the law. The second objective that I seek to achieve in my research is to develop what I call or consider a normative framework for social rights adjudication. And so in this regard, what I seek to do is respond to what some people may be familiar with, but is a long-standing global debate about the appropriate role of courts when it comes to social rights. And a lot of people around the world have written on this and continue to write on this. So we have Martha Jackman here, as well as Margot Young at UBC, so that's in the Canadian context. There's a number of people in the US who have written on it, including Catherine Young, Frank Mickelman, David Landau, Mark Tushnet. In the UK, people like Jeff King, Sandra Fredman, Paul O'Connell, and I could go on. It's hard to summarize this debate in kind of a short way, but essentially what it comes down to is there's, I guess, two extremes. On one end, there are people who say, well, courts shouldn't be involved when it comes to social rights. These are polycentric issues of policy. Courts do not have the legitimacy to be dealing with these issues, and so courts should just stay out, and they should defer to the government when it comes to these issues. And then you have on the other extremes people saying, well, courts need to be involved. They need to protect interests. They have a role as protector or enforcer of rights, and so to give them no role doesn't make any sense. And a big portion of this debate is about trying to find a middle ground, trying to find a role that courts can play without either usurping or abdicating. And so here in Canada, it's not just a theoretical debate, but we have a number of cases that have come out in the last kind of 10 to 15 years at the Supreme Court level. So we have Gosselin, Otten, and most recently a Tani-Jaja case. And so what I'm trying to do in my work is I suggest that the concept of trust can actually provide a new and what I consider a helpful way of looking at this particular debate, and in turn carving out a role for courts in this particular field. Okay, so that's enough background. But before we can kind of do all of this, we can reconceptualize in terms of trust, and we can try to carve out this role for courts, we need to actually ask the preliminary question that's the topic for today, which is, what does it mean to trust? And in particular, what does it mean to trust in this particular context? And if there's one thing that I think is relatively universal when it comes to the trust literature, is that people generally accept that trust is a very context-specific concept. So before we can actually use it in a helpful way, we need to do some work to understand what it means and what it means in a particular context. And so that's what I'm trying to do today, and get everyone thinking about what exactly trust and what it means to trust. So before actually doing that, there's just 2 points that I want to make, 2 preliminary points I want to make. So one question that you may be asking, and it's a good question, is why trust? Why should we care about trust? Why should we be reconceptualizing in terms of trust? And why use trust in this normative framework as I'm suggesting? And those are all good questions, and unfortunately I can't go into these questions in the detail that I'd like to go into, because they would be a topic in and of themselves. But I can say 2 points on this relatively briefly. One is that trust is not a new concept in law. There's a number of scholars in public law, outside public law, who have written on the concept. And so it's been used by a number of scholars in contract law, trust law, fiduciary law, medical law, the list goes on. And what all these scholars agree is that trust is an important concept, and we need to give a little more weight to the concept of trust when we're talking about what the law is and what the law should be doing. The second thing that I can say with respect to this value of trust, or why we should care about trust, is that there's quite a lot of social science evidence which establishes that public trust in government is really important or critical to the functioning, or to well-functioning democracies. And in this regard, it's been said that trust is linked to cooperation, and particularly it's linked to citizens' willingness to accept authority decisions and their feelings of obligation to obey laws. And so such cooperation, particularly in the social rights context, we can think of if we want citizens to pay their taxes, if we want them to invest in government, and thereby we want to enable governments to provide the various social goods and services that we're talking about, we need to think a little bit more about trust. And more broadly, this form of cooperation that follows from trust has been tied to such valuable ends as social stability, economic welfare, and effective governance. And there's a lot of people who have written on this, and I can refer you particularly to Tom Tyler, who's kind of cross-pointed between psychology and law, who's done a lot of work on procedural justice and these ideas. The second preliminary point that I just want to make really briefly is trust is a difficult concept to address because we all have our own intuitive understanding of what it means to trust. And so whenever I talk about trust, people jump on me and say, that's not trust, or that is trust, or what about this? And it's fair, but at the same time, kind of hopefully keep an open mind, think about kind of methodically what exactly I'm trying to say and what exactly it means to trust. And so while it is a big part of what I do in terms of describing what it means to trust, I think an equally big, if not bigger part, is defining what exactly trust is not. So I need to rule out things that people get confused. And so as I go along, you'll see that I'm drawing distinctions between trust and related concepts, or in questions I may be responding to these things, and so I just flagged that for now. And to start things off, what I want to do is draw my first distinction, which is a distinction between political trust, which is what I'm going to be talking about today, and what's well known as social trust. And so people usually, when they think of trust, they think of social trust. And by social trust, I mean trust, the trust that we have in one another. So people talk about kind of trust as being ultimately representing social capital. There's the importance of citizens trusting one another. We need to work together. And I'm not disputing any of that evidence, and I'm not disputing any of that research, but it's just not the focus here. So when I'm talking about political trust, I'm talking about citizens' trust in government. And particularly I'm looking at citizens' trust in the elected branches of government. So with all that said, that was quite an introduction. Let's talk about trust. So, to situate the conceptualization in something a little more concrete, I'll start off with a scenario. And it's a scenario that has become increasingly common in modern welfare states. And that is legal or potentially constitutional challenges to a government decision not to fund a particular healthcare treatment. So, for example, if people are familiar with kind of the challenges to governments failing to fund applied behavioral therapy in the Otten decision, or in vitro fertilization in the Cameron decision, and there's other, I'm referring to those because of the Canadian examples, but there's cases in other countries. And so in this context, or in this scenario, we're told, and I think correctly, governments have finite resources, and they must necessarily balance competing demands. So simply put, governments can't fund everything for everyone. And so what governments do is they make decisions. They make decisions as to which particular treatments are funded and which particular groups will be included or excluded from that funding. And so the question I ask is, what does it mean for a citizen to trust the elected branches of government with respect to this type of decision making? And so in answering this question, I'm going to do so in three principal steps. One is I'm going to define what I refer to as a trust relationship. And by trust relationship, what I'm talking about is a relationship in which it's possible for trust to arise. And in that respect, I distinguish it from a trusting relationship, which is a relationship in which trust does exist. So a lot of people say, you'll see the next step that I try to recharacterize the relationship between citizens and government as a trust relationship. I'm not saying we all trust our government, everything's great, let's go on and live a happy old life. I'm trying to say that it's a relationship in which we can actually talk about trust because trust is a possibility. The second is, like I said, I'll proceed to reconceptualize the relationship between citizens and the elected branches of government. What I refer to as the citizen-government relationship, I know it's a bad term, but it's just the easiest way to stop talking about using too many words. And I try to reconceptualize that relationship as a trust relationship. And then the third step I will actually get to is defining trust itself. And I define trust in terms of three expectations, which I'll get to shortly. So let's proceed with each of these steps. So first is defining a trust relationship. So it's well accepted in the philosophical literature that trust involves a three-part relationship. And so there's three parts to it. There's a trustee, which is the person being trusted. There's a truster, which is the person doing the trusting. And there's a good resource or service that is at issue. And so based on my reading of the literature on trust, there are four elements that I consider to constitute a trust relationship. Four elements that are required in order for trust to arise in a relationship. First is control. The trustee must have control over a good or service which the truster needs or wants. So if you want to, just to give it a bit more concreteness, pretend I'm the truster and you're the trustee. So first is control. You have something that I need or I want. Two is discretion. That's the trustee has discretion in how he or she exercises that control. So you can choose, you have discretion in how you're going to exercise control over that thing. Three is uncertainty. So by uncertainty, this is reflecting on me, not you. The truster is uncertain as to how exactly you're going to exercise that discretion, or how you're going to exercise your control over that good or service. And the fourth is vulnerability. And so by vulnerability, it's once again reflecting on me, the truster. It's that because of the fact that I need or want the thing that you have control over, and you have discretion in exercising that control, I'm vulnerable to you. Does that all make sense? And so these four elements, and I go into more detail in the paper, but these four elements constitute what I call a trust relationship. Now, I suggest that the relationship that I'm interested in, which is the relationship between citizens and the elected branches with respect to social rights, the citizen-government relationship, it may be reconceptualized as such a trust relationship. And hopefully it doesn't take that much work to explain what I mean by that. So one is we can reconfigure the relationship. So the trustee would be the elected branches, the trustor would be citizens, and the good or service at issue would be the various goods or services that we think of when we think of social rights. So things relating to healthcare, things relating to education, things relating to housing. So these things may be, for example, physical goods, personnel, infrastructure, equipment, benefits or services. So just to consider in the healthcare context, we can think of pharmaceuticals, trained doctors, nurses, and healthcare professionals, hospitals and clinics, machines and beds, medical procedures. These are all things which the state has control over in a modern welfare state, and the things that citizens need or want, but with respect to social rights, I'm focusing on things that we theoretically need. So now that we've reconfigured it, the question is, how do the four elements apply? So first, control. I think it doesn't take that much of a stretch to say in a modern welfare state, if we're working in a welfare state, the elected branches do maintain control over a number of social goods and services. And when we're talking about social rights, we're usually talking about things that citizens need rather than focusing on want, although there's some ambiguity there. Second is discretion. Once again, I don't think it's hopefully too much of a stretch or too contentious to say that the elected branches do have some discretion in exercising their control, so both at the legislative level and the executive level. So the legislature in promulgating legislation, in deciding what's covered, what's not covered, in deciding where funds should be distributed, they're exercising power, or they're exercising discretion. Same with the executive. A lot has been written, for example, Lawrence Dawson at Osgood has written on discretion exercised by administrative decision makers. So if we can accept that there is discretion, so we have control and we have discretion, then uncertainty. So given the discretion that is vested in the elected branches in exercising control over social goods and services, I would consider uncertainty to be inevitable. So in the citizen-government relationship, this uncertainty exists on multiple levels. One, we have an uncertainty that, unfortunately, we won't get everything that we want out of the process. So I may want a particular medical treatment, but I may not get it. The second is, and that is much more important in my view and troublesome, is that citizens' interests may be disregarded, or maybe minimized, or worse, disregarded in favor of the elected branch's interests. And so particularly when we're talking about social rights and we're talking about low-income individuals, and a lot of people, social rights scholars, have written about this, but the problem is that low-income individuals, their interests don't resonate well with the interests of either bureaucrats or politicians. And so they tend to basically draw the short straw when it comes to getting their interests represented. And then finally, in terms of the four elements, is vulnerability. So owing to the elected branch's control and discretion that they exercise over social goods and services, coupled with the fact that citizens need those goods or services, citizens are exposed to a certain degree of vulnerability. And I go into quite some detail in the paper, but I don't want to have that much time. So one thing I will say is that this vulnerability, unfortunately, is not uniform. And so depending on the personal circumstances of the individual and depending upon, both the life circumstances and the extent to which the control exercised by the trustee is exclusive versus partial, will have some effect on the extent of vulnerability that's ultimately experienced. So I think hopefully I've done a sufficient job to kind of reconceptualize the citizen-government relationship as a trust relationship. So that brings me to the third step, which is, okay, so we know what a trust relationship is. We know that potentially the citizen-government relationship can be recharacterized as a trust relationship. What exactly does it mean to trust? And so building upon that body of literature that I mentioned in terms of trust. What I do is I define trust in the social rights context as a set of positive expectations held by citizens regarding the manner in which the elected branches will exercise their control over social goods and services. And so there's two points or two components to that I want to break down for a bit. One is that idea of a set of positive expectations held by citizens. And so quite a few scholars have written on trust and have written on the idea that trust can be represented as a set of expectations. And so particularly they define trust in terms of three expectations. One is an expectation that the trustee will exercise goodwill towards the trustor. Two is an expectation that the trustee has the technical competence to fulfill his role, that is, to exercise his control over the good or service in a competent manner. So the basic idea there is that it may be great that the person you're trusting has goodwill towards you and has the best intentions towards you, but if they're not competent to do that which you're trusting them with, the trust just can't be there. And then finally, the third element is that in certain relationships of fiduciary nature, there's an expectation that the trustee will fulfill his fiduciary responsibility to the trustor. So extrapolating those three elements to the citizen-government relationship, we can define trust in the citizen-government relationship as three expectations. One, that an expectation that the elected branches will exercise goodwill towards citizens. Two, an expectation that the elected branches have the competence to exercise their control over those social goods and services. And three, if we accept that the citizen-government relationship is fiduciary in nature, which a lot of work has been done on this, and for example, Evan Fox-Decent out of McGill, as well as many people in the United States. But if we accept that we can characterize the citizen-government relationship as fiduciary in nature, there's a third expectation, which is an expectation that the elected branches will fulfill their fiduciary responsibilities to citizens. I'm really short on time, so what I'll do is, if you have any questions on this, I'm happy to elaborate, but I'll move on from there. So the second element of the trust definition, in addition to that set of expectations, so it's a set of expectations regarding the manner in which the elected branches exercise their control over social goods and services. And so what do I mean by that? Well, the three expectations that I've used to define trust regard the manner, not the outcome of the exercise of control. So in other words, it's the procedure by which the exercise of control takes place. And as I've alluded to, there's another expectation which a trustor may hold vis-a-vis the trustee, and that is an expectation regarding outcome. That is an expectation about whether or not the trustor, or the trustee, in the end will provide the good or service that's wanted or needed. So for example, if I trust you, I can trust you with respect to the three expectations I've set out, which are with respect to the procedure, or I can trust you about whether or not you're actually going to give me the thing in question at the very end. And some people have written on this and have said, well, that third one, that expectation with respect to outcome is trust. And there's actually quite a body of literature talking about the fact that it's not actually trust. And I side with these people. And I do so for a few reasons. One is there's quite a lot of empirical work that establishes that, going back to what I said at the beginning of this talk, if we're focusing on the value of trust as being that focus on cooperation, the empirical work shows that those ends with respect to cooperation are actually achieved by focusing on procedure, not outcome. So whether or not we end up cooperating, we accept authority decisions, we comply with laws, it depends on whether or not we trust with respect to procedure, not with respect to outcome. The second is, I think if you follow it logically, it doesn't, if you focus on outcome, it doesn't make a whole lot of sense. So in my view, what it does is it leads to a misconception or a confusion between trust and dissatisfaction. So, for example, if I expect a certain outcome and that outcome is not produced, I ask you a question: have you abused my trust? So I want something, you don't give it to me. Have you abused my trust? Now, I may be unhappy, I may be dissatisfied But I think it's a bit of a stretch to say, just even from an intuitive level, to say, you've abused my trust, that you are not trustworthy. There may be circumstances beyond your control that wouldn't let you produce that outcome. Now, in contrast, if I expect a certain procedure and that procedure is not followed, have you abused my trust? I would say, yeah. I think that makes sense. I think it's not, you can't control the outcome, you can control the procedure that you're ultimately following. So with that in hand, and just to kind of wrap up, let's return to the scenario that I set out at the beginning. So, and let's use specifically the Autumn situation, which is the funding of ABA, or applied behavioral analysis treatment for people with autism. So as I asked at the beginning, what does it mean for citizens to trust the elected branches with respect to public healthcare funding decisions like that, whether to fund the ABA? So based on my definition, it means, one, that citizens expect the elected branches in making such decisions that they will exercise goodwill towards them. They have good intentions, and as I elaborate more in the paper, that they will use fair procedures in exercising that control. Two is an expectation that citizens' interests will be considered and will not be minimized or disregarded in favor of the elected branch's interests. And in there we have kind of that fiduciary interest or that fiduciary responsibility element. And then third, I think this is a particularly important one, is trust would involve an expectation held by citizens that the elected branches would make the decision of whether to fund a treatment like ABA on the basis of complete and accurate information. And in this regard, a lot of scholars have written on the idea of evidence-based decision making. And so for us to trust our elected branches doesn't just mean that they'll exercise goodwill towards us, but that they have the competence to do so. It means that they'll, not necessarily that they themselves have it, but where they don't have it, that they'll go up and get it. So, with that said, where does this leave us? Well, in terms of my research, if we accept that public trust in government is a valuable end, which I haven't gone into that much detail about it, but as I've said, the social science evidence supports that public trust in government is in fact a valuable end. And if we accept, based on my reading of the social science literature on trust, that trust in the social rights context indeed is how I've conceptualized, that is a set of positive expectations held by citizens regarding the manner in which the elected branches exercise their control over social goods and services. This begs the question, how do we incorporate this into our legal system? How do we further public trust in government, and more specifically, can it provide some guidance on the difficult questions that I outlined at the beginning with respect to the role of courts? And that is where ultimately my research is taking me. Thank you.
Thank you, David, very much. And now we're going to have comments from Professor McConnell.
Thank you very much. Thank you for coming. When Colleen Flood asked me to act as a discussant, I kind of scratched my head and said, why me? I feel, whenever I come to law school, I feel like a little bit of an interloper because my training, while it's in political science, it's most definitely not in law. And while you can't get a decent political science degree with doing some political theory, I won't claim to be a theorist by any stretch of imagination. So my comments are going to reflect my background both as a political scientist, as a health policy, I'm interested in health policy, and as you'll see in a minute, somebody who spent a lot of years in government. Broadly speaking, I think I recommend the paper to everyone. It's a very careful and very thoughtful analysis of the concept of trust. And broadly speaking, I think there is much to be gained by thinking about the relationship between citizens and their governments as a trust relationship. I think that can be a fruitful way of thinking about it. And to that extent, I'm not going to engage directly with the philosophical arguments about the nature of trust, nor, I mean, the paper offers a very compelling account and a very nice linkage between the empirical research, where you ended, on the empirical research about what we know about people when we empirically examine how they think of trust and all of that. So all of that I think is fine. But I want to make a couple of comments, both on terms of the role of law and of courts in this process, and second, to drill down on your healthcare example, which you didn't talk much about in your talk, but are part of elucidating or illustrating what the relationship between citizens and governments might look like, and how that applies to social rights. So, at the beginning of his talk and in the beginning of the paper, he sketches these two extremes as to the role that courts and law can play. Now, for a whole bunch of reasons, I'm on the skeptical side. I am deeply skeptical of the role that courts can play in not so much the definition of rights generally, and social rights in particular, but in their enforcement. The paper is not meant to resolve that dispute, I don't think, but it left me unconvinced. But for a reason that is not mentioned in the paper that you might want to think about, which is the ability of courts, and this was the core of the critique around the decision in Shauli, the ability of courts to understand and think through and take into account the complexity of making policy in these areas. Shauli, to my reading, is a singularly good example of what happens when courts break down in their ability to think through social rights. Now, we're doing this all over again in Vancouver as we speak, and I suspect that this today will end up in the Supreme Court. So the Supreme Court of Canada at least will get another crack at this. But there's also research that asks the ability of courts to take into account empirical and social science evidence. And the message from that literature, as I read it, which I'm a specialist in, is, not so much. But again, this is not the main point of the paper, so I just remain a skeptic, but the point of the paper was not to convince me otherwise. And here, so the next point I want to make about courts, though, is in reconceptualizing the relationship as one of trust, you write, courts may use the concept of trust as an adjudicative tool for social rights cases, making their objective therein to generate conditions under which citizens may trust the elected branches. As a political scientist, I find that claim rather extraordinary. The notion that courts would generate conditions under which citizens may trust strikes me as a rather expansive reading of the role of courts in democratic society. But again, this may simply reflect my ignorance or my bias as a political scientist, because I have to admit I haven't thought long and hard about the role of courts and law in democratic society. But this is a subset of when I do health policy and I read health law. In so much of what's written in health law, I could substitute political science. So there's the way we structure health law conversations in North America is we let the lawyers do all the heavy lifting, and social scientists do not think as systematically as lawyers do. But it has the effect, I think, that it gives a pride of place to courts and law that I think would be appropriate. So let me move on to some comments about the healthcare example. Broadly speaking, the argument in the paper is, it applies to the Canadian case, is governments as the trustee have the ability to deliver, in this case, health care, health services, and then the paper thinks through what that looks like in light of the rest of the analysis of the paper. So my comments are simply cautionary and on the margin. But first, I'm struck by the gap between the claims in the paper about social rights and the reality on the ground. So in the United States, for example, there's by no means agreement on the claim that in fact the state has a role in ensuring health care, much less a constitutional obligation to do so. In the United States, well, there's an agreement, for example, that the state has a role in health care for the elderly, Medicare, or Medicaid, and in some cases, children. There is by no means agreement, in the United States at least, on the role of the state in providing health care more generally. But more generally, I have control with the suggestion that governments, quote, have control, and even indirect control, over health services. I submit that that varies by country, the United States in contrast to, say, Sweden or Canada. And it also varies in terms of what kind of services we're talking about. So I don't think that governments have direct control or even indirect control over things like the quality of medical services we receive. And by no means do they have control over various bits of public health, where all of the diversity is infectious disease. But I want to drill down, and this is simply, if you're going to make this argument in Canada, I accept the general argument, but the specific one I have problems with. So in order to demonstrate this claim that governments have control over healthcare, in the paper you write, the provinces have exclusive control over medically necessary healthcare services. Well, this is strictly speaking true, but firstly, it's only true in some provinces. Only some provinces have legislation that does that. And second, it only applies to doctors and hospitals. So you need to spend some time in the paper defining medically necessary, because as defined by the court, as defined by the Canada Health Act and by the courts, it doesn't include prescription drugs, home care, various bits of community care. Similarly, you claim quite boldly, and I quote, under the Federal Canada Health Act, provinces are legally required to provide their residents with a healthcare insurance plan which insures all medically necessary healthcare services. Now, if Colleen were here, we would get the definitive answer. But in the absence of Professor Flood, I will go out on a limb here and say that's just wrong. That in fact, it reflects a common misconception of the Canada Health Act. But in fact, all the Act does is say, and let me quote from the Act, establish criterion conditions in respect of insured health services, blah, 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 blah. The provincial law must be met before a full cash contribution can be made. In other words, the government of Canada says to provinces, we're going to shape the way you deliver health care, and we're going to bribe you with money to do so. But we're not going to legally require, we cannot legally require you to do so, because we don't have the constitutional authority to do so. Having said that, I think you can save your argument by focusing on specific provinces like Ontario, which has its own legislation that binds where it seeks to bind itself in terms of what it's going to do in respect of health care. So I don't think the Canada Health Act is the place to look, but there are individual provincial statutes that might do so. So let me change gears completely and I'll end on this point. At some point in the argument, in the paper, you make the argument that this trust relationship matters and the adjudication of social rights is particularly important for marginalized populations and low-income people. And in the paper, you go on to make the claim that there is a tension, if not a contradiction, between the interests of bureaucrats and politicians and those of the people who are ostensibly they serve. And you make a pretty classic public choice argument. You write, bureaucrats and politicians have their own interests when making political decisions. For bureaucrats, it is to maximize budgets and power, and for politicians, it is to maximize votes. And you want to write, bureaucrats' interest in maximizing budgets and power necessarily run contrary to the interests of low-income citizens in maximizing social welfare. This is one view of both bureaucrats and politicians, but it is by no means the only view. Niskanen, do I pronounce that right? Niskanen's model of the budget-rising bureaucrat is a common one to be sure, but it is highly contested in the literature. It goes back, oh my goodness, 30 years, but there's been much written about it since, and I'll give you some references. But second, to the extent that it's true, to the extent that we do have budget maximizing bureaucrats, a public service and politicians responsible for social welfare will, by this argument, have an interest in maximizing the social welfare budget. So I don't think even if you accept the general public choice argument, I don't think it can be universally true that all politicians and bureaucrats, their interests run contrary to the interests of low-income citizens. If you're the Deputy Minister of Health, and I work for a couple, or if you're the Deputy Minister of Social Services, you have a huge interest in maximizing your budget because that's what you're kind of there to do. And finally, depending on the country, the party in power, or other factors, like contrasting generous welfare states like Sweden and Norway versus more conservative places like the United States or the United Kingdom. A politician or government consistently ignores the interests of low-income citizens, does so at their peril. So at one point you argue that a strong welfare state which entails regulation of commerce and redistributive tax spending is diametrically opposed to the interests of the wealthy and precisely the target of well-resourced lobbying interests. Again, this is one conception of how welfare states works. It is one conception of how policy making works. And I dare say, in certain situations, it's very accurate, particularly in the United States. But for a wealthy and well-organized society, consistent underinvestment in social welfare risks disorder. There is in the United Kingdom a benevolent Tory tradition that says that the state has an obligation to make at least a minimal investment in social welfare because this is what gives rise to a well-ordered state. And I think that Tory notion exists in Canada as well. And when that doesn't happen, as at the state level in the US, you get disorder. But second, I have trouble reconciling this general claim with the continued existence of progressive taxation and redistributive investments more generally. And I'll end on this point. When we characterize the healthcare bargain in Canada, we sometimes say that public funding of doctors and hospitals is a transfer from, quote, the generally healthy and the wealthy to those who are needy. In other words, the bargain, the trust relationship, if you will, that exists between Canadians and their governments, and indeed in most advanced welfare states, at least those with expansive healthcare systems, they are fundamentally redistributive. And so I think you need to temper or moderate your claims about the fundamental contradictions between the interests of governments and the citizens who have to serve. So I'll stop it.
So thank you for those extremely thoughtful comments. And I'll invite David back up to answer, I'm not answering any questions, I'm going to invite David back up to answer questions. So just raise your hand and we'll start off, we'll let David get up and then we'll start off with John Packer back.
Thanks, David, for the talk. I have to say I'm rather troubled by the persistent reference and the necessary ingredient in your formula, focus on the citizen. Not only is that problematical in terms of essentially a fundamentally contractualist paradigm, but it's not at all coherent with existing international law, nor, I would say, with a host of other political paradigms which now prevail around the world in terms of responsibility, specifically state responsibility. So it's really what you're talking about is a pre-1945 paradigm in terms of general international law. Because the post-1945 paradigm is that the state is responsible for all persons within their jurisdiction, not citizens, all persons. And applicable international human rights law is even more precise, everyone. Specifically, the obligations under things like the International Covenants on Economic, Social, and Cultural Rights, which do make some accommodation for developing states with regard to resources and social security, therefore do not make accommodations for developed states. We're not quite sure what that division is, but for a developed state like Canada, this simply shouldn't apply. So I find it really difficult to square this. I like the idea of trust, but that's a kind of reductionist idea too. There should be more than trust. There is simply responsibility. And in hard international law, it's state responsibility. This is not a matter of what the population wishes to agree with or not. Inter pares, between states, that is an obligation of international law. And this has direct effect with particular groups. For example, in this country, we've had this problem with regard to refugees, who are, generally speaking, by definition, aliens. So they come into the country, and then we say, oh, no, but they don't have any rights to health care. And whatever we give them is a matter of our kind of largesse, or, if we want to be nice to them. But we have hard obligations, not only on the Covenant of Economic and Social Cultural Rights, specifically under the Convention on Refugees. So I really think this is not only limited paradigm, I think it's actually a problematical paradigm. It's feeding into an old thinking, not a progressive thinking. I won't even go near to the comments of the commentator, because I think that's even old thinking. And I invite Martha, David, and others to talk about things like judiciability. I mean, it's well established that actually the courts deal with housing, education, and other disputes all the time. It's a massive area of judicial engagement. So the idea that they're not equipped or capable is just so empirically false as to be laughable, seriously. And very much based on rights, not to mention international rights. But my problem is your focus on the citizen. I think that is more than problematical. I think it's actually wrong.
Do we want to take one more question? I think Martha, we'll take Martha and David, and then we'll go answer all three.
Thanks, super interesting paper. Really, it's nice to have somebody come and maybe think about something a different way or reorganize it. So I really understand what you're suggesting with the idea of goodwill. You have to be competent, although I know Shawnee really goes wrench into that claim. And you have to respect your fiduciary obligation. And I think the question that Patrick was asking, if the courts make sure that the state does that, we'll trust the state more. But I'm interested in the courts and what happens in the context, you're talking about socioeconomic rights, where the courts are ill-willed. They could be competent, but they don't give a shit to develop the competences. I think, David's given them a guidebook about how they could improve in the score. And they have no respect for their fiduciary obligations towards those who are needy. Like, I know politically the sanction is you throw the bums out, but I know now I'm way outside your paper, it's not what you took on, but I guess my interest in this, I think the analysis is so interesting. So people living in poverty clearly do not trust the courts because they do none of these things. In the judicial realm, have you thought about sanctions or mechanisms for recalibrating the relationship?
Thank you. Take one more.
Yeah, I agree. I think it's really interesting as well. I would share John's concerns and Martha's and some of the points raised by Patrick. I guess, so apart from being interested in your talk from a social rights perspective, I also teach trust, so I'm interested in the trust component. I'm just going to concentrate on what concerns me, okay? I mean, I think like Martha said, I think there is a lot that's interesting here and potentially useful. But I guess there's two things that concern me about the intersection of trust and social rights. On the social rights point, and it goes to what Martha's question was, it seems in the end, unless I misunderstood you end up with a proceduralist paradigm of rights protection under the guise of trust. So you're only concerned with the procedure as operated in a trustworthy fashion rather than the outcome. And for me, that would be a problem if that's all that our social rights guarantees are via trusts, is proceduralist, because I think that's letting ourselves off the hook when it comes to social rights guarantees. Then thinking about trusts, I guess I'm concerned that in your definition of the elements of trust, the one thing you don't have there, or when you talk about it as a need and the trustee controls and et cetera, all the control, of course, is, and discretion and all that is all part of the trust relationship. But the key bit about trust, of course, is that it's a property relationship as well. And what the trustee has control over, in fact, belongs to the person who's doing the trusting, right? It's only the equitable interest in strict property law. But I think that I'm worried that has fallen out of your idea of trust, because it seems to me, in fact, that would give it important ballast if you brought back in the idea that what is being controlled by the trustee is something that ultimately, at some level, belongs to the person who's meant to be trusting, or in other words, is something to which they're already entitled, not something that they just may happen to need. Then that would help to close the gap, because as far as I am aware in terms of trust and fiduciary obligations imposed on governments in sort of quasi-social rights contexts, they're very reluctant to see the government as a fiduciary, obviously to anyone except First Nations and other Indigenous populations. And so I think there's they're reluctant to do anything there, and then to get rid of that important element might be leaving us with even less. So.
Thank you. Thanks, sir. So I guess, broadly speaking, I think you're 100% right with respect to kind of my paper does go, it's quite broad. And so I guess that's kind of the hard part when you're talking about something quite theoretical. So it could use, and it will, in terms of the future chapters and future elements of the PhD, it will go into a bit more detail and allow me to focus in on particular case studies. And so obviously there will be differences. One thing I will say is that, and I've tried to do it quite carefully, and maybe it's not careful enough, but I am limiting myself to what I have defined as contemporary democracies with a welfare state. So I'm not really including the United States because they would be they have certain elements of, I guess, a welfare state, but they're quite an exception. So they'll usually, get difficult when you're dealing with this kind of issue. With respect to the back, you're 100% right with respect to my focus on the citizen, and I guess maybe a dissatisfying answer, but when I say citizen, I don't mean citizen. And I've had this discussion with many people, and there's just no good word to use. So if I use resident, then it doesn't necessarily apply. I've tried using person, it doesn't necessarily apply. So, and maybe it needs to be more set out, but and every system will be different. So for example, in the UK, under the NHS, as a resident, you're entitled, but then in other places you have to be a citizen, in other places you have to be a permanent resident. So I guess, I don't know if I'm answering your question, but it's just, there's no real good word to use. So really what I'm using citizen in place of person, human being, individual.
I can just push back on that. I mean, so in international law, for example, the UN Human Rights Committee has been quite clear. Even tourists have rights of protection and entitlement. So but we can imagine someone who, for example, has a heart attack on an airplane that gets diverted. I've actually been on such an airplane, flying to New York, gets diverted to Gander, the guy's had a heart attack. Now the question is, they're within the Canadian jurisdiction, does Canada owe anything to this person? Or is it just kind of good luck to you? And international law is quite clear that yes, there is a duty. And so you might think about gradations, and other words which have been used are denizens, residents, and so forth. There may be gradations, but I wouldn't want, and I'm glad of your response, I wouldn't want it limited to the classic sense of citizen in the sense of a national state.
No, I absolutely agree with you. I just, and I think the decision itself as to what is included in citizen would itself be subject to the trust analysis. So it's not, maybe I need to be a bit more careful, but I had no intention of limiting it to a person who has citizenship of the country in question. With respect to your other concern about my focus on trust, you're 100% right. And once again, I don't mean to suggest that trust is the only end, the be-all and end-all. And so, feeding into Martha's question, I'm using trust as a basis for trying to assess courts, and so I'm interested in trust. Now, there will be other ends, like for example, in international law, there are obviously, we've signed on to covenants, and there are minimum core obligations and things of that sort. And so, absolutely, it's not just we've satisfied trust, we're all good, we can all pack it up and go home. There's obviously bigger responsibilities, bigger obligations. The question that I'm trying to address is, can courts address those obligations? And as much as we, as lawyers, we want to talk about courts, there are other institutions, there are other organizations, there are other bodies that have a role to play. And so I'm kind of using trust, A, I'm interested in trust, and B, as a way of kind of conceptualizing what courts can do. Does that answer your question?
Thank you.
Okay. With respect to Martha's question, yeah, you're absolutely right about courts, and so it's, I don't want to call it a weakness in my argument, it's essentially, so what I'm using is trust to kind of give away into what courts can and cannot do, or should and should not do, because of all the limitations that are out there with respect to capacity, competence, and polycentricity. And so what I do in terms of my future research is, by setting up this idea of a trust relationship, once again rooting myself in the social science literature, I make an argument for the fact that if we want courts to impact trust in the citizen-government relationship, what ultimately I do is I set up what I call the network model. And it's an idea that one trust relationship impacts another trust relationship. And so what necessarily follows from that is the extent to which our relationship with the courts can impact our relationship with government will depend on the level of trust we have with courts. And so I guess what I would say to your question, and you're right, is I'm trying to make the best of a bad situation. So I don't want to suggest that courts are our savior, that courts will do everything. But I'm trying to use trust as a way of defining a role for courts. But you're absolutely right that there will be, and we need mechanisms that will allow us to trust the courts themselves. But it's just not what I'm focusing on right now, but you're 100% right. And it's kind of a precursor to my research that before we can have the courts do anything, I guess I'm working on the assumption that we trust courts, but we're going to need to put in place controls and ideas about how we can work with that relationship. And it really depends on the jurisdiction that we're talking about, because there's some, like now working in the UK, I'm much more familiar with people telling me, we trust government, we don't trust our courts. And then you go to another another country, and they say, well, we trust our courts, but we don't trust our government. And so it's just, and that's kind of where my research kind of takes me. And then finally, David's questions with respect to, so first, the question of the procedural paradigm. Is it all that social rights guarantee? No, but once again, I guess what I'm trying to do is I'm looking at what courts can do. And so it might be a bit of a cop-out in the sense that courts need to go further. They can't, because if they're not enforcing the rights, then who will? But I think, first of all, procedure will take us a fair bit of the way forward. At least it's better than non-justiciability, which is based on tender jaja, that's where we are now. And the second
Let's not
thing,
admit that.
Sorry?
Let's not admit that. We don't want tender jaja to have cred.
Okay. Well, let's hope that, yeah. But what I will say is, so right now in terms of my thinking, it's not what social rights are all about. It's not what social rights are limited to. We have international obligations, and we also have other institutions that can play a role, other bodies that can play a role. I guess what I'm trying to say is I think courts can, potentially procedure is a valuable role for courts, at least right now, given the limitations that have been set out. Because unfortunately, you're right, there must be a middle ground. And so potentially, and I think what I like about kind of this idea of trust is that, like for example, if you're familiar with the South African context in terms of the reasonableness analysis, what I don't like about that is that it's all backward looking. And so the courts will essentially say, look back at the decision, and usually they'll look at the decision itself rather than the procedure, and they'll say, is it a reasonable decision? And so many South African scholars have criticized those decisions for saying, well, we have no idea what reasonableness means. It basically means whatever you decide it means on that particular day. But there's no forward-looking precedent out. So hopefully, I think with trust, and by focusing on these three elements of trust, it at least gives the courts and everyone out there some idea of what forward-looking we can do. In terms of your property interest question, you're 100% right, and so I haven't, hopefully haven't ignored it. So when I'm talking about control, for example, there are different ways in which I talk about in terms of a trust relationship that control can come about. And you're 100% right that control can come about because you just naturally have control of the thing in question. But it can also be that I entrust it to you. And so you can conceptualize the relationship between citizens and government as that entrusting. But I don't think the end will ultimately be any different, whether or not you have control over it because of the fact that I've entrusted it to you, or like it does raise fiduciary questions, but but in terms of what it means to trust, it's not any different. Does that make sense?
Okay.
And there's also...
I don't know if I'd agree.
Well, I guess
see the point.
there's also the fact that by having the fiduciary expectation, it does serve that end. So that's why social rights or social science scholars have recognized this fiduciary expectation of fiduciary responsibility, because in certain situations, because things have been entrusted to another person, or because the thing that they've been entrusted with is so complicated that I can't understand whether or not you're competent to do it, or I can't understand whether or not you have goodwill, that fiduciary element is there. And so it takes a bit of convincing to say that governments do have that fiduciary responsibility. But I think that, maybe I have to give a bit more thought, but I think that is kind of covered or helps with the issue of whether or not there's kind of a distinction between whether or not it's been entrusted or just flat out.
The power relationship is completely different in the two scenarios. Isn't it? I think why fiduciary law is so powerful is that it's mine.
No, you're absolutely right. But I guess what you're talking about is what are the obligations as opposed to what does it mean to trust. So,
I know, it just sounds like you're asking to build it around trust, but it's almost like, it's not entirely blind faith, it's like looking for a favor or whatever, as opposed to, this is mine. I haven't been given the power to decide all these things in relation to it, but so ultimately you have the power, but it's mine. You can only exercise your power over my stuff with my best interests at heart. So just, I don't know, I'm not sure, it doesn't make a difference whether you see the person as having an entitlement, some sort of inchoate, whatever entitlement in the thing. They have an entitlement to their healthcare treatment or whatever, or to good health. And I think it potentially does make a difference if you think that they have a sort of pre-entitlement to the thing, which in a way they've just given to the government to manage on their behalf because we live in a complex society. But ultimately the government maybe it's accountability.
Oh, it's where the rights come in.
Yeah. We've got 5 minutes left, so we're just going to take 2 questions. We have one here and then one at the back. Yes, please. Go ahead.
Thanks. I'm not a lawyer, but just 2 questions. One is about what I take to be a sharp distinction that you draw between procedure and outcome. And if you have a sequence of procedures that all in the small look okay, but the result is that one minority group tends to be incarcerated a heck of a lot more than another, is that, could it be a fair procedure but a terrible outcome, or is that does the outcome feed back into your judgment or assessment of the fairness of the procedure? Question 1. And question 2, you describe control as if the government was some huge amorphous blob with a dictator at the top that was omniscient. But certainly in the healthcare system, we know that the minister of health has so much he or she can do, deputy minister, but then there are agents like doctors who maximize their income sometimes, beyond the control of the elected representative. So don't you want to dissect a little bit, this idea of control as not being quite so simple?
Okay, let's take one more here, and David can respond.
Well, this is quite a different question, and I thank you for this talk, and I admit I didn't read the paper, so, but I guess I'm wondering how robust do you think, how much work do you think this notion of trust can do? I think that we sometimes have trouble with the notion, like with rights talk, social rights talk, particularly within everywhere, but within a country, and sort of trying to make sense of what that really means with a pretty highfalutin word like rights. So I wonder if what you're suggesting is that down the road, and if not, why not, that actually trust talk can replace at least some of the work that rights talk is doing in a more accessible, maybe more common sense, maybe more sort of workable kind of way that for some circumstances we don't need to use rights talk. We can have trust talk and do the same work. Is that sort of where this thing is going, or do you think, or do you see a different sort of relationship between trust and social rights?
Please. So really quickly, with respect to the distinction between procedure and outcome, I think you're right, and it's not the easiest distinction between the two. I guess what I'm trying to say is, it's not that the outcome in question is beyond the realm of kind of review. It's not, I'm just questioning whether or not courts should be reviewing that outcome. So, and procedures may, you're 100% right, they may lead to completely unjust outcomes depending on the situation. But I guess whether or not courts are in a position to be engaging in that and questioning that outcome is a different one. With respect to the issue of control and being not so simple, I guess you're right. Once again, it's kind of the difficulty of being at a theoretical, talking at a theoretical level. And so I recognize the complexity, and so it requires a bit of kind of digging down as you go into it. But I guess at the end of the day, like when we're dealing with kind of social rights cases, we are talking about at a very broad kind of level about what can and cannot be done or who has control. And so I don't know whether or not. I guess you're right about the issue of control. It's not, none of this is as easy as, and I think that's the problem with social rights scholarship, is that we're trying to find some easy solution to a very, very complicated problem. But I'm hoping that, this is not the end. This is nowhere near, that I've offered the solution and we can all, that's it. It's just kind of to get us talking about something. And with respect to the question about trust talk versus rights talk, I think trust can do a fair bit. I think trust leads us to a lot of where scholars are already talking about. So I'm not the first person to be talking about fiduciary responsibility or to be talking about evidence-based decision-making or goodwill for that matter. And they've all kind of been coming up different pipelines, and I think that trust just kind of gives us a nice little package that we can and there's, like I said, there's a wealth of trust literature, and I think we as lawyers can really make use of that because people have been thinking about this for decades, and so maybe there is some, insight that can be drawn from that. With respect to it replacing rights talk, my fear about letting it replace rights talk is kind of what I was mentioning here in terms of social rights. I don't think the procedure and the idea of trust can replace that we have international obligations and that there is more to social rights than just, like for example, under international law, there's an obligation for progressive realization. And so we can't say that just, trust can replace it all. There's more to it, and we need to, so it's, I don't want it to replace anything, I just want it to potentially provide a way in the courts. And I think just generally talking about trust can help us to think about the relationships in a new way.
So we've got another class, I think, ready to come on in any minute. So I want to thank everybody. Thanks to our speakers. Time to break.